Stephen Telemaque. Inmate 06215-104.
I am writing to request your help and assistance in any manner you can provide to me. If you are unable to assist me, would you please provide me names and numbers of lawyers willing to represent me on a pro bono basis? I have been in federal prison for six years now and have little to no money. I am requesting help with my federal case. I am actually innocent as the facts of my case show clearly that I was convicted of a non-crime, i.e., the substance was not listed as a controlled substance under federal law at the time of my offense. This was demonstrated in the United States Court of Appeals for the 11th Circuit case, United States v. Pfeiffer, 909 F.3d 372, 11 THCR 2018. My case is similar to the Pfeiffer case in substance. See, United States v. Telemaque, number 1:15, CR 20531, SDFL 2016. I have pursued a direct appeal, conviction and sentence affirmed, a motion to vacate, set aside, or correct a sentence pursuant to 28 U.S.C. 2255, that was denied before the court even considered the merits. An application for a certificate of appealability to the 11th Circuit as to the denial of the 2255 motion, which was also denied. I filed a motion to void judgment of denial on my 2255 motion pursuant to Rule 60(b) of the Federal Rules of Civil Procedure, which was also denied. This was followed by an appeal of the 60(b) motion to the 11th Circuit, which was also denied. Finally, I petitioned the United States District for the Eastern District of Kentucky for the writ of habeas corpus on my claim of actual innocence, that was denied. This was followed by appeal of the denial of my habeas corpus petition to the United States Court of Appeals for the 6th Circuit, which was also denied. All my filings were done pro se. I have no legal background or education. I do not know what I am doing wrong or how to go about getting my unlawful conviction overturned. I am diligently pursuing my rights, but I am at a loss as to why I am continuously being denied relief. I am in desperate need of your help, please. Thank you for your time and consideration with this matter. I cannot express how much I greatly appreciate any help you can provide. If you are willing to provide an email address so that I can send you a Corlinks invitation, it will ease communication on both our ends. I look forward to your prompt response. Until then, I remain respectfully yours, Stephen Telemaque. U.S. v. Telemaque No. 1:15, CR 20531 SDFL 2016. My case is an 11th Circuit case out of Miami, Florida. The substance I was charged with is ethyl 1. Ethyl 1 was not banned by the CSA until after my offense.
I responded to Stephen in a letter and told him I published his story to my YouTube channel and would try to help by way of research and attention to his story. First, I reviewed his direct appeal to find out why they denied it.
Before Jofflat, William Pryor, and Anderson, Circuit Judges. Per curiam. Stephen Telemaque appeals his conviction for conspiracy to possess with intent to distribute a detectable amount of ethyl 1. On appeal, he argues that the district court abused its discretion in denying his motion to withdraw his guilty plea. He argues that his plea was not voluntary because he would not have entered it absent the mistaken advice from counsel that the proper ethyl 1 to marijuana volume conversion ratio used in sentencing calculations was 1 to 500. Upon review of the record and the parties' briefs, we affirm Telemaque's conviction. A district court abuses its discretion if it fails to apply the proper legal standard or to follow proper procedures in making the determination, if it makes findings of fact that are clearly erroneous, or if the denial is arbitrary or unreasonable. There is no absolute right to withdraw a guilty plea prior to imposition of a sentence, and the decision of whether to permit withdrawal is left to the sound discretion of the district court. Defendant seeking to withdraw a guilty plea after its acceptance but prior to sentencing must show that there is a fair and just reason for doing so. In determining whether a defendant has met his burden to show a fair and just reason to withdraw a guilty plea, a district court may consider the totality of the circumstances surrounding the plea, including whether 1. Close assistance of counsel was available. 2. The plea was knowing and voluntary. 3. Judicial resources would be conserved, and 4. The government would be prejudiced if the defendant were allowed to withdraw his plea. Appellant does not satisfy the first two factors of the Buckles analysis. We need not thoroughly analyze the remaining factors. The good faith, credibility, and weight of a defendant's assertions in support of a motion to withdraw a guilty plea are issues for the trial court to decide. Statements made under oath by a defendant during a plea colloquy receive a strong presumption of truthfulness. Consequently, a defendant bears a heavy burden to show that his statements under oath were false. The timing of an appellant's motion to withdraw a plea also deserves consideration, as it may be indicative of the defendant's motivation. G. Under Rule 11, before a court can accept a guilty plea, it must inform the defendant of his rights should he plead not guilty, the nature of the charges against him, the potential penalties, the court's obligation to calculate his advisory guideline range, and the terms of any sentence appeal waiver in the plea agreement. The court must also explain that a guilty plea waives the defendant's trial rights and ensure that the plea is entered voluntarily and is supported by a sufficient factual basis. Further, the court must explain that the defendant can be prosecuted for perjury for testifying falsely under oath. Rule 11 does not require uncontroverted evidence of guilt. Instead, Rule 11 requires evidence from which a court could reasonably find that the defendant was guilty. We have affirmed the denial of a motion to withdraw a guilty plea based on a defendant's contention that he relied on his attorney's underestimation of his potential sentence under a plea agreement where the defendant was informed of the applicable minimum and maximum penalties, that he could not rely on his counsel's prediction, and that the sentence actually imposed by the court could differ from any estimate the defendant received from anyone, including his attorney. We have also held that a district court abused its discretion in denying a defendant's motion to withdraw a guilty plea that was based on incorrect statements in the plea agreement that his prior convictions did not qualify as predicate offenses for purposes of an enhanced sentence under the Armed Career Criminal Act and that he faced a maximum penalty of 10 years imprisonment. In addition, we noted that the Symington District Court twice erroneously stated that it could sentence the defendant to a maximum of 10 years imprisonment, and thus did not comply with Rule 11's requirement to inform the defendant of the possible maximum penalty of life imprisonment and the mandatory minimum penalty of 15 years imprisonment that he would be subjected to by pleading guilty. Here, the district court did not abuse its discretion in denying Telemaque's motion to withdraw his guilty plea. First, Telemaque had the close assistance of counsel because counsel was appointed before the superseding indictment was returned, and counsel advised Telemaque about the charges against him, the advisory sentencing guidelines, his plea agreement, and other matters about the case to Telemaque's satisfaction. That Telemaque's counsel did not advise him of the possibility of an ethylene conversion ratio of 1 to 250, based on a district court case that had not yet been published before Telemaque entered his plea, did not demonstrate that he lacked the close assistance of counsel. Second, Telemaque does not contend that the district court made any Rule 11 errors and never stated that he would not have pled guilty but for his counsel's allegedly defective advice about the ethylene conversion ratio. Telemaque has not shown that his affirmations at the plea colloquy that he understood the terms of the plea agreement, that the court could impose a sentence more severe than the guidelines called for, and that he could not withdraw his plea if the sentence was more severe than he expected were false. Moreover, at sentencing, the district court released Telemaque from the plea agreement provision requiring that he recommend a 151-month sentence, which was the primary reason Telemaque gave for wanting to withdraw his plea. and the district court calculated a lower guideline range based on a 1 to 380 conversion ratio, and heard Telemaque's argument that he should receive a lower sentence. Because Telemaque's plea was knowing and voluntary and he had the close assistance of counsel, we need not thoroughly analyze the remaining factors.
It appears to me that his case may be lost under AEDPA. I'm wondering if my viewers have any thoughts about this case. Please comment below or email duckandfelonies@gmail.com. Thank you for watching and please consider signing my AEDPA petition. I only have one signature. I need 98 more. Special thank you to my supporter of the petition.
Yeah.